Good afternoon, everyone. Welcome to Tea Time with JK and Co. So today we'll be discussing on the general topic on civil action. So today we have three speakers to share this topic with us. Our first speaker is Yuan,
Hi everyone, my name is Yuan.
and our second speaker is Mr. Jason,
Hello, everyone.
and our third
Thanks
speaker
for
is
joining.
Mr. Satya.
Hi everyone.
Okay, so before we start today, if you have any question related to today's topic, you can leave your comments or your questions in the comment box, and our speakers will address all these questions at the end of our session today. So today, basically, we will be talking about three areas of civil action, which is small claims, how to commence a civil action, and also what to do if someone sue me. So for small claims, it's basically like if there is a claim less than 5,000, what do you need to do if you want to claim this money? And this will be explained by Siren. And then the second area, which will be explained by Mr. Jason, will be how to commence a civil action. Like if you want to claim back a higher amount of debts, or if you want to claim back any property, or you want to take a civil action or legal action against another person, what do you need to do? What are the documents that you need to prepare, and what are the procedures, or this kind of issue and also procedures? It will be explained by Mr. Jason. And the last topic will be explained by Mr. Satya, which is what if someone sue me, which will be the defendant. And if you receive some of the letters and also some court papers from other lawyer, what do you need to do? Is there any way you can defend yourself, or is there any way to settle all this kind of problem? So this will be explained by Mr. Satya. So now I will pass the time to Siren, and she will explain with us about the small claims.
Hi everyone, my name is Yuan. I will explain to you more about the part of small claims procedure in Malaysia. Maybe some of you still didn't aware about the existence of small claims procedure in Malaysia. So first of all, let us get to know what is meant by small claim court. It is actually a court to hear cases which the amount of claim is less than 5,000 ringgit Malaysia. And if you wish to understand more about small claim procedure in Malaysia, you can actually refer to Order 93 of Rules of Court 2012. You might be asking, what are the types of claims that I can go for small claim procedure? Let me show you some example, such as if you want to claim for rental due or recovery of debts or some less serious injuries, you can go for small claim procedure as long as the amount of claim is less than 5,000 ringgit. Another thing is that a plaintiff cannot be represented by a lawyer or legal counsel in small claim proceedings. In other words, if you want to initiate a small claim procedure, you need to represent the action by yourself. And you might be asking also, normally small claim procedure is heard by who? And it is actually here and decided by magistrate court. Let us go further. Next, I'm going to explain to you some of the basic procedures regarding small claims in Malaysia. It is stated under Order 93. First of all, like any other civil claims, you will need to fill in your claim in a writ in Form 198. Maybe you will be wondering, where can I get this Form 198? You can actually get it at the Registry of Subordinate Courts, or you can refer to the Schedule of Rules of Court. After you get the form, you will need to fill in the form and sign the form. After you've done all that, you will need to prepare 4 copies and submit to the Registry of Subordinate Court with a prescribed fee. After that, you will get a hearing date, whereby you will need to attend on the hearing date itself. Following date, the registry will seal the writ and you have to serve the form to the defendant either by hand or by registered post, as long as it was brought to the attention of the defendant. After you serve to the defendant, you will need to file in a document named as Affidavit of Service to prove that you had actually successfully served to the defendant. Let us move on. This is the Form 198 which I mentioned earlier. You can actually refer to the Schedule of Rules of Court to see this form. Next, I'm going to continue with a part of defendant in small claim procedure. Maybe you will be wondering, what can a defendant do in small claim procedure if a small claim procedure is initiated against a defendant? This is the position under Order 93, Rule 6, whereby a defendant can actually deliver his statement of defense in Form 199. Similarly, the statement of defense need to be filed in 4 copies, and there's actually a time frame for the defendant to file, which is within 14 days after the service of claim on him. What are the content that we need to insert in the statement of defense are such as reasons of disputing the claim, or maybe the defendant have any counterclaim. How much is the counterclaim? These are some of the content that we can put in the statement of defense. Similarly, after defendant fill in the Form 199, he has to serve to the plaintiff. If there is any counterclaim, the plaintiff can also file in his reply to such counterclaim in Form 200. All these forms you can actually get in the Registry of Subordinate Courts, or you can refer to the Schedule of Rules of Court. Okay, there might be a situation where after a small claim procedure initiated against a defendant, and defendant admits the claim. In this kind of situation, a judgment can straight away entered into, but your judgment need to be entered in Form 204. Before I ending my part, I would like to recap on some of the important points. The first one is, in small claim procedures, the plaintiff must be individual. In other words, the plaintiff cannot be agent or assignee of a debt of any other person. Secondly, the general rule in small claim procedure is that plaintiff or defendant cannot be represented by any lawyers. However, the position of defendant is slightly different from plaintiff, whereby the defendant can actually represented by lawyer if it is required or authorized by the law itself. Last but not least, your question might be, if after the court gives us a judgment or order, however, the defendant or the judgment debtor fail to comply with such judgment, then what can the plaintiff do? For this, we can refer to Order 93, Rule 16 of Rules of Court. The plaintiff can actually file a notice to show cause, which specifically in Form 208, in order to enforce the judgment or order. And let us see what are the court powers to enforce such judgment or order. Under Order 93, Rule 16 of Rules of Court, the court can actually order a WSS, or we call it as writ of seizure and seal, or order the judgment debtor to pay the debt within a time frame, or to order the judgment debtor to be sent to prison. These are some of the court powers in relation to enforcement of judgment or order. So basically, this is my sharing about the small claim procedure in Malaysia. Maybe you did not aware about the small claims procedure in Malaysia, but from our talk today onwards, you know there is an existence of small claim procedures in Malaysia, and I hope my sharing can give you some useful knowledge on this part. I would like to pass to Mr. Jason on how to commence a civil action. Thank you.
Yeah, thank you, Xuan, for sharing with us on the small claims procedure. Yeah, so this is whereby I think the amount is substantial in the sense that it require a solicitor to represent you in court, right? As you're aware that any amount that more than 5,000, that you can take up the matter in civil court, right, instead of a small claim court. Now, before you commence your legal action, it is very common in our society that somebody wanted to sue somebody, but many people will be asking, how do I going to start? Now, it is an easy way out. It is to look for a lawyer. Your preferred appointed solicitor will represent you, and there are something that you will have to take note of. or aware as a plaintiff. Plaintiff is represent means that the person who wanted to take up action against somebody. So there's a name for it. It's called plaintiff. Now, before it start, you will have to issue a letter of demand. Your lawyer will have to issue a letter of demand. So the wording speak for itself. It is to demand something, to request something, or maybe for the goods so deliver that the debtors have not paid you the goods that send it over. So you might want to recover the monetary action. So that letter basically to give notice to the defendant or to the debtors for repayment. Now, in order to do that, there are several questions here that require probably a checklist. You must identify who you are and how much you are claiming. So in that sense, that you must also identify how much is your losses, or in the sense that the goods so deliver that the invoice indicate how much money that you wanted to take or claims from your customer, your client that didn't pay you. Now that is have to be clearly ascertained. For goods so deliver example, you will have to tender your invoice or at least a quotation or DO, delivery order, shows that the goods has been delivered. And so this are documentary proof that you must get yourself ready before it is in the extremely clear sense how much amount that the other person owe you. Then this letter of demand will be spelled out in a series of goods that have been delivered and how much it costs to pay back to you. And of course, it usually in the letter of demand, at all instances, we are giving a timeline to repay the money. It's either 7 days or 14 days to repay. And in return, you might encounter there's a reply saying that is that possible of prolong the payment or by way of installment. It is all subjective. It all depends on parties, right? The other thing is that you will have to important. It is one important point is to identify who is the defendant, because the party's identification is important. Otherwise, the letter will go landed on the wrong person. That doesn't give you a good footing to start an action. So, who own you money, whether it is an individual or whether it's a company, we have to identify that. So that all this information that you be able to identify, then you can actually issue a letter of demand. Now, if you look at the next slide, we basically wanted to talk about when you wanted to sue someone, you must have a cause of action, or in Latin wording is called locus standi. Means that you must have a locus to sue before you commence an action. Now, what is a cause of action? It basically defined back in the 70s itself. A case law tells us what is cause of action. Basically, a cause of action is that the action that you can be taken to sue somebody, and when the facts happen are material to prove entitlement for the plaintiff case to succeed. Now, goes back to the same analogy that I'm highlighted just now. It is about the goods so delivered. Now, good has been sold, delivered, and you have not recovered your money. No money has paid to you. That is clearly as cause of action given to you, which you can start the matter in the civil court. Yeah, before you begin, like I say at the very beginning, we have to issue a letter of demand. Cause of action have to establish. Okay, so if you move on, we move on to the next slide. Then you will see we talk about this locus standi. Locus standi simply means that you have the rights, you have the capacity, special interest to bring an action to court. Now, a lot of people out there probably might just wanted to sue for the sake of suing. Now, I can warn you that you must actually pass this test. That we must come as a solicitor. We will come and identify the issue for you, and we will give you an opinion whether your case have a ground to sue or not. So this locus is important because it is a foundation or basis of a civil matter, right? So we move on to the next slide. Now, if the defendant once receive your letter of demand and they are not responding to you, or to a matter that the person that own your money do not want to respond and do not wanted to pay you, even though they respond, but they have no way they are interested to pay you, in that case, you can actually start an action in court. Now, usually it is by way of summons or originating summons. Now, there is a difference here because OS, we call it in short form, originating summons, likely to have it is a straightforward matter. Unlikely there's a substantial dispute. For example, if someone own you rental, it is a straightforward. You have a tenancy agreement. Every month you have to pay rental. So a straightforward case, we can start by way of OS, right? Now, if you look at the next slide, it is a different thing. It is a more substantial dispute. Like, for example, in a situation of goods sold deliver, yeah, it is true that I issue you an invoice, you haven't paid me, but probably because of the goods, there are some defect. So that might be some return goods, credit notes will be issued, and so on. So the calculations of the outstanding might be adjustable. The amount that you claim have a different opinion than the defendant. So all these are disputed facts, have to be litigated in the civil court. Those substantial dispute, we will have to start the matter using by way of a writ of summons. So which is a very common thing. A lot of people will start this action. We file the summon and statement of claim, right? So these are the documents to initial after the letter of demand has been issued. Now, the as far as the after the letter of demand, people might ask, when can I quickly start the action and recover my money? Now, the thing is this: once you issue a letter of demand, 7 days is lapsed. Immediately you can actually start an action. You file to get the lawyer to file the matter to the court. He extracted the summon and statement of claim that have to be served. All right, served to the defendant. So that is why it is important to identify who is the defendant, where are they located, where is their address, because as far as the writs and the statement of claim goes, it has to be personal service. Otherwise, it's AR register post, right? So if you look at the next slide, now this is a statement of claim. Normally, it's filed together with the summons. That statement of claim is where it will spell out all the list of entitlement of the plaintiff. Now, I'm going to sue somebody for 100,000, so I'm going to spell out why is it 100,000 that I'm suing. You have to illustrate the facts. It is all indicated in the statement of claim. Yeah, so if you move on, then you will see the timeline. The next slide will tell you the timeline. After the writ is sealed by the court, then we have to serve to the defendant within 6 months from the writ summons. That means every summons will have an expiry date of 6 months. It is by personal service or AR register post. Now, what happens if the defendant, having received your summons and kept quiet and not going to do anything about it? Then the plaintiff will have to attend the case management in court and inform the court, look, we have duty served, we found an affidavit of service, the defendant failed to attend court. Then the plaintiff will proceed to obtain a judgment in default of appearance. It is a permission by the court. If the defendant don't turn up to court to answerable to the debts claims, then the judge will award or entitle the JID of appearance. Now that is where you will get a JID. We call it judgment in default. So let's look at the JID here. Now, if we, which means when the court make a decision that the judgment has been obtained without presence of the defendant, like I say, file an affidavit of service, the court is satisfied and you are entitled for JID, the court will allow. So once you got the JID, next step is to enforce the judgment. All right, enforce the judgment by many means. Let's look at the next slide. Now, the next slide, you can see there are final judgment, there are interlocutory judgment. So there are different type of judgment that we obtain. Now, final judgment, it is required normally for breach of contract, possessions of immovable property. So normally it need courts to assess the money because it is have to be clear on the judgment sum. interlocutory judgment is basically unliquidated damages. Need the court to assess the amount and not to base on the amount stated in the statement of claim. For example, a defamation suit. So those are the different type of judgment. Now, there are instances where the defendant appeared in court, right? They came up to court and filed a defense. So normally, what happened is when they file a defense means that the case is go on. So that means you were going to litigate the matter. It is not a situation where the defendant didn't come to court. They come to court. Now, once the defense is filed, the plaintiff will then have to put out a reply. Once the pleading is closed, means that okay, I file defense, you file claims, I file defense, I put out a reply. Once the pleading is closed, now the next case management, the court will direct all the party to compile a common bundle. It is where if it for good so deliver or any other matters that you are suing in court, you will have to gather all the necessary documents, compile together. You will have to file it to court. Why do we want to file the common bundle? It is because we are heading to a trial. A court will then give you a trial date. A trial date will be fixed. Then you have to attend court. Now, along the way, when you're heading for a trial, you are expecting to prepare yourself a witness statement, because you will probably, other than the documents in court, you might want to realize on some oral evidence. The parties appeared in court to give evidence. So those are the witness statement have to pre-prepare before the trial date. So during the trial, how many witnesses going to be present, how it's going to do, all will be handled and managed by the lawyers at the court. So currently, just an update, because of the pandemic, all of us are slowly and converted most of our cases into an online trial. So we basically trying to adapt this transition, and it is a new norm to lawyers and judges. We're going to conduct the trial via online, via Zoom. Yeah, it can be done. We have done some cases, and of course, it is at the discretion of the parties. If the matter have no choice but have to go to court, then the case have to postpone, because since everyone is locked down at the moment, we can't actually go to court. Court is not open. Now, during the trial date, basically, the list of witnesses will be present. It will start from the plaintiff witness first, then goes to the defendant witness. Now, once the trial is complete, you will then proceed for submissions, for submission for trial, and then there will be a decision. That is so long as the plaintiff case from A to Z in a very short period of time. That illustrate to everyone. Hope that you get the pictures of how's the litigation process of a recovery of money. Yeah. So of course, we didn't talk so much about there are also summarily to delve in some of the cases by way of summary judgment. So in other words, not all cases will go to full trial. Yeah, there are some straightforward cases. You can be winning the matter by way of documents to show to the court. You can actually heading to the court by way of summary judgment. So if you obtain a summary judgment for that particular case, it means that you don't have to actually go to court to run through the entire trial. Yeah, so that is the, we'll call it the interlocutory application to court to obtain a summary judgment. So these are the options and relevant procedure provisions are in place for all the general public who wanted to take up an action in a civil court. Now, that is so far as the plaintiff case is concerned. Perhaps I can proceed to pass to Satya to talk about how about defendant's case. Yeah, thank you.
Thank you, Mr. Jason. I hope all the viewers you all stay safe and during this pandemic. Okay, my learned friend Mr. Jason already explained how the suit will be initiated and what the plaintiff can do or cannot do. And I'll be explaining more on the defendant, which you need to defend when someone files a suit. In the usual practice, when a plaintiff sends a LOD, which is a letter of demand, which can be known as notice of demand or letter of demand. My advice: try not to ignore it, because although it's not so serious because some people will ignore it. For example, for example, which I can tell, a defamation case. If you receive a LOD, you have to rebut back. There's a two ways you can reply to the LOD, which is can be via your lawyers or by personal or under company. The moment you get letter of demand, you need to, the best person usually I would advise, if you know the case very well, the individual or the company can send the reply to the letter of demand by themselves. But as a lawyer, we would advise to engage a lawyer because they will know better in the legal side. First thing, the moment you receive a letter of demand, need to know, clarify if you do not understand. You can send reply to them saying that to this particular thing, to reply back to their letter of demand, say that I do not understand, or I'm looking for further particulars, further details on the particular claims that they have been alleged against the defendant. If it is wrong accused, send a prompt reply to defend yourself. But like I said, you can I'm repeating, you can also find a lawyer to help you to dispute the claim. If the claim or whatever they allege is untrue, or you can through yourself or through a lawyer, you can arrange for a repayment or do some arrangement for the payment for the whatever claim that been claiming by the plaintiff. And you also can negotiate by having settlement on without prejudice basis. Why we are telling that when you're doing a negotiation without prejudice basis, sometimes the settlement can be failed. When the settlement fail, they can't use this letter, your correspondence in court in any event if they file a suit. If there's no word without prejudice, they can use the letter, be a part of in their claim. They can state part of their claim. That will show to weaken your case. So but the best is better to engage a lawyer because sometimes the legal term can trap someone. If it's a very straightforward claim, then you can go like goods delivered, and so you can negotiate through. If you want to negotiate, you can negotiate through your lawyer or yourself or anything, and you also can rebut by yourself or by a lawyer. But when it comes to negotiation or something, it's better to have the word without prejudice, so that you won't prejudice your case or your defense later when they're filing a suit when the plaintiff files a suit against the defendant. Next slide. Okay, like my friend Mr. Jason said that when a plaintiff initiates a suit, usually they'll file writ and statement of claim. The writ is shows with the parties, and same goes to the statement of claim. Statement of claim, I would say like that's the story of their side, why they are claiming this X amount against the defendant. It could be company or individual. That's their version of story. So the moment a defendant, a company or individual receive writ or statement of claim from the plaintiff lawyer, I would advise you have 14 days from date of receive to enter appearance. You can enter appearance by the company, if a company, you can get the representative of the company to enter the appearance. If individual, you can enter yourself, or you can appoint a lawyer to enter the defense, to enter the appearance. The moment you enter appearance, that means they can't get judgment in default against you because you are either being represented or you're representing yourself to defend the suit which has been filed against you by the plaintiff. Next slide. If you receive a writ and statement of claim, you can defend yourself, but it's the moment you enter appearance means you are defending. That means after entering appearance, you have decided to defend, and you have to serve a defense on the plaintiff. Usually, it will be on the plaintiff solicitor within 14 days after you have entered appearance. For example, if you enter appearance on 12th July, You got 14 days from there, which is 26 July for you to file same of defense. Just say in the same event, there's a whatever they're claiming is untrue or you're defending or it's true. We see it's a based to case to case basis. Just say in a simple example, like Mr. Jason said, good delivered and sold. Well, they say they're claiming you X amount. But in other end, you also in the same transaction with the same company, they still owe you. So therefore, the defendant can file a counterclaim against the plaintiff. The moment the defendant file a counterclaim against the plaintiff, the suit in the counterclaim, the defendant will become a plaintiff and the plaintiff will become a defendant in a counterclaim. That's how it works. The moment you have a counterclaim, the plaintiff subsequently, after you serve a statement of defense and counterclaim by the defendant to the plaintiff solicitor, the plaintiff, through their solicitors, they have 14 days to reply to your defense and defense to counterclaim after that. If you wish to reply to the defense to counterclaim, then you have to seek permission. You have to seek a leave from the court in order for you to reply. So it's not necessary for you to file a separate suit against the plaintiff if the same just say involve a same company, same transaction, or is just say same company, same transaction, they owe you. There's not necessary for you to file a separate suit. You can bring it, the defendant can bring it through a counterclaim. Next slide. This is could be a lot of people. Usually a lot of people ignore this. When if the moment they file a suit, when the plaintiff serve a rate and sum of claim to the defendant, which could be individual or company, or could be both in the same suit, they'll ignore. So the moment they ignore, that means, like I said, there's no appearance been filed. There's no you never defend yourself. The moment you never file your appearance, that means you're not defending yourself in the suit. So what will happen, as like my friend Mr. Jason explained earlier, they can enter a judgment in default of appearance against you. After the 14 days, they serve the writ and summon and statement of claim. Within the 14 days, you enter an appearance. If the defendant failed to enter appearance, then they'll file a judgment in default of appearance against the defendant. But that's not end of the day, because the moment they have the judgment in default, they can use that to execute against the defendant. The mode of execution could be a bankruptcy or could be a garnishing. There's a lot of execution process. I mean, for individuals, if a company, you can go for garnishing, you can go for winding up. But it's not the end of the day. The moment you get just say you ignore and the plaintiff solicitors serve the judgment default to you. So after that, subsequently, you can appoint a lawyer. Usually, we'll advise you to appoint a lawyer because it involves a legal part. If the particular defendant can do by themselves, can represent themselves, please proceed as well. Then, the moment you receive a judgment in default of appearance, you can set it aside. After under Order 42, Rule 13 of ROC, which is Rules of Court 2012, says that after the judgment is served to the defendant should apply to the court to set aside the judgment within 30 days. Just say I serve to you within you receive it on 1st July, judgment default from the plaintiff solicitor. So within 1 month, you will file a setting aside an application to the High Court through your solicitors or yourself to set aside the judgment default. And Order 13, Rule 8 also, court has discretionary power to set aside the judgment. Is to see to case basis. If within 30 days, usually it'll be more to like a technical or on a technical ground usually. If you fail to technical ground, then you have to look into the merits of your defense, because you have to propose your merits, your proposed defense, to show that this case should go for trial. So the moment if defendant fail to set aside JID within 30 days, then there's a subsequent ways also where within the application also, in the application, the defendant through their solicitors, they'll apply for permission to the court to extend the time under Order 3, Rule 5. So what happened if within 30 days, the lawyers might file under Order 42, Rule 13, Rules of Court to set aside the JID. Just say it's above than 30 days, then the defendant's solicitor will apply under Order 3, Rule 5 and Order 42, Rule 13 as well. Because it's a mandatory to cite the order to see whether you receive within the 30 days or after the 30 days. After that, the moment you file an application to the court, you serve to the plaintiff solicitor, then the plaintiff will file an affidavit reply. Then you will file an affidavit reply. The moment an affidavit is exhausted, then the court will give further direction for parties to file their respective submission, which will be done by the solicitors to support case laws and the argument. The plaintiff will argue, saying that the JID should not be allowed, application should not be allowed. Under why? Depends on your reasoning. While the defendant said the application should be allowed, and why the reasoning is that. The moment the judgment is set aside, then it goes back to the original process, whereby the court will give direction for the defendant to file a enter appearance, file defense or counterclaim. Then the plaintiff will file a reply to defense, and the process will take part. But it's not the end of the day. In any event, if the judgment default could not be set aside, just say defendant's application is not allowed, they still can appeal to further high court. As an example, if they start from high court, then they can go to court appeal. If magistrate court or sessions court, they can appeal to high court. So there's avenues. It's not end of the day. Next slide, please. So, in a nutshell, the moment in a trial, the moment like Mr. Jason said, when they come to trial, the defendant need to defend. Usually the burden is more high on the plaintiff because they need to prove to the court why the claim should be allowed, while the defendant should defend and say that why the claim should not be allowed. But during the process, just say after judgment default is set aside and going back to the by looking the court direction, like Mr. Jason said, after court give direction to file bundle of documents, just a defense document, plaintiff document to be part of the court facts and issue and other relevant documents. But at the same time, when Mr. Jason said, when the defendant have a weak defense, they can file a summary judgment. But in the other end, the defendant also can file striking out application if their claim is it could be many grounds. Example, usually local standi, where they sue the wrong party. How Ms. Suen explained earlier. Because in order for someone to take an action, they must have local standi. If in the suit is supposed to be party C, but they sue the party D, so the party D can strike out. The moment they strike out, the plaintiff can appeal as well. If in a summary judgment, if the summary judgment has been allowed for the plaintiff, the defendant can appeal as well. Then after that, parties, if he's going for full trial, the parties will take testimony. Each respective plaintiff witness and defendant witness will give testimony, their witness in court. After that, parties will file submission, like how Mr. Jason said. Then the decision will be given. Then either party who are not satisfied the decision given by the judge, they can appeal to higher court. That's all from my side. Thank you very much, everyone, for listening to us. Back to you, Natalie.
Thank you all the speakers for sharing. Because through this talk, actually, I believe that some of the audience have some questions, and one of the questions we would like to know is if there is there any way to actually avoid to enter into the court. For example, if I want to settle with anyone for small claim or for civil action also, is there any other way compared to entering into the court once I receive the writ of summon or this?
Yeah, perhaps I can just get the ball rolling. Yeah, of course, I think the most foundation of the dispute it is to have a matter resolved in a settlement manner, right? So now we might proceed to mediate the matter. As far as the negotiation take place, negotiation can take place, and round table talks can be happen between parties. Settlement can be resolved without even go to court. In fact, the court nowadays are more favorable than before, where parties are more encouraged to have the matter to mediate to a mediation center, to have the matter resolved without even go to court. Now that is also contributions towards of uh, a backlog of court cases. Yeah, so in fact, the judge is also encouraged parties to mediate the matter instead of litigate until the end. Like I say, there are options. Through a letter of demand, another solicitor respond, it can be negotiated in that manner, or from your lawyer to talk to the defendant or the debtors. Probably will set a meeting with the defendant and see how can the defendant pay off the debts. Now, if the negotiation successful, then you don't have to go further. Then the plaintiff will also get his money back. Yeah. So yeah, there is other options other than going to court.
Just to add on that, it's not end of the world the moment you enter to the court, because in between, while the court direction was going on, parties still have a room to negotiation, which is known as out of court settlement. So if parties agree, then they can enter in a judgment which is known as consent order or consent judgment. The parties have agreed the terms and conditions. And at the same time, sometimes, like Mr. Jason said, the court also are pushing to mediation for nowadays, because the court have the facilities where they have their mediators, qualified mediators, to mediate the matter. Back to you, Nathan. Thank you.
Okay, thank you, Mr. Jason and Mr. Satya. I also have another questions related to this. So from the plaintiff side, means if they started to sue someone and then the defendant also reply, means they're actually going to court, but then suddenly this plaintiff wants to stop suing. Maybe she has another problem and she decided to stop suing. Is this possible? Can they do that if they want to stop from suing the defendant? Is there any consequences?
Yeah, perhaps I can just start. Yeah, you can. You can actually withdraw the matter if you wanted to start something and meet of the trial, or not trial, but then meet of the case at any stage you wanted to withdraw, or you want to record a consent judgment, is possible. This all depends on the circumstances of the case. If the matter has progressed and what Mr. Satya have told us, matter have been resolved by way of a negotiation through a mediator, it is successful resolved out of court, perhaps the matter can be end up to enter a consent judgment. Yeah, so it is a one way of stop the matter. The other way to stop it is a full withdrawal on the account of the debtors promise to pay, or probably pen down to a settlement agreement, and the plaintiff would wanted to withdraw the matter altogether, right? So that is also another way of have the matter to stop. Yeah.
Thank you, Mr. Jason. Because I was
Sorry,
yes,
Natalie.
Yes, please.
Of course, the defendant will more than happy if the plaintiff is withdrawing entirely the claim against the defendant, who don't want to be. Sorry. But in that circumstance, it depends on the circumstances. It's like what Mr. Jason said. But some withdrawal they don't have a liberty to file afresh, because there's maybe it could be a. It depends on the arrangement. It depends on the case-to-case basis. Back to you.
What Mr. Saturday mean is actually means that if someone withdraw, then later they want to sue back, it's actually maybe they cannot sue back, right? On the same.
Yes, because the word I use without liberty to file afresh. It depends on case-to-case basis. Case-to-case basis. It's not in entire applicable in entire case. Because it could be why? Because it could be other arrangement, or could be the subject matter being dealt before. It's got many could be many reasoning for that.
Okay.
Thank you.
Thank you, Mr. Satya. And we also received a message from our audience to actually ask a question related. Is there any other alternative way, like if I want to recover my debt, like for example, I find a company to help me to claim back my debts or this kind, is it okay to do so because I don't want to enter court or this kind of matter? Is this an alternative way, and is it a better way?
Yeah, I think I'm not quite sure of any other company offering. I do heard of some of my clients are saying there are private entity out there, private company who claims to able to recover debts for your company. So debt recovery company, we'll just take it that debt recovery company are not a law firm, so they can't actually pick up the matter in court. So I think that there are companies out there to claims that they can actually recover. Yeah. So the way that I've observed of how they recover is normally they will do CITOS. I think they will so-called blacklist debtors or secrete them. Yeah. So this is what I commonly heard of. Yeah. Thank you.
Okay, thank you, Mr. Jason, and also thank you all the speakers for answering our audience questions and also my questions. So through today's talk, we actually just like to alert everyone to hope that you all will know about some basic legal procedures if you want to take, if you would like to take action or you like to claim something. For example, even you want to claim a small claim like which does not exceed 5,000 and you think that it's a small amount, you are actually quite confused whether you can actually claim or not. Don't worry, you can actually claim even though it does not exceed 5,000 ringgit. We also hope that through this talk, everyone will also know what to do if you want to take a legal action, or we also hope that you will understand what to do if someone take action against you. We just like to advise not to ignore whatever things that is sent to you. For example, lawyer letter. Try not to ignore all these documents as it would be quite important for it will be somehow important for your case in the future. So at the same time, for today, I also posted this Google form in the comment section. If you have any feedbacks or you have any suggestions of talk you would like to know or you are interested in and you hope we can actually address to these talks or these topics, you can fill in this Google form which I posted under this comment section. So once again, thank you very much to all our speakers for sharing and also answering the questions, and also not to forget all the audience who joined us today. So next week, we will also have our talk about the tenancy and also lease. So if you'd like to know what are the differences between this tenancy and also lease, in what kind of situation you have to enter into tenant and also what kind of situation you have to enter into lease, so you please stay tuned us on next Sunday, 3 p.m. to know more about this land matter. So thank you, everyone. Bye-bye.
Thank you. Bye.
Thank you, everyone.
Thank you,
Stay safe.
everyone. Take
Thank
care.
you for viewing.
Stay safe.
Take care. Bye.